Hello, everyone, and welcome to this edition of Macro Pro and Friends webinar series. Today, I am with my friend, James Rossi. James, how are you?
I'm doing very well. Thank you, Diane. How are you?
I am fantastic. I see behind you, you've got little bobbleheads.
I sure do.
I bet there's a lot of baseball fans out there. So tell me about your prize bobblehead.
Well, I don't know if these are all my prized one. Actually, I do. Now that you say it that way, I do have a prized one, and it's Vin Scully. I love that one. Vin Scully is one of my favorite baseball people. Even though he didn't play, he had such a great personality. He was an amazing person off the field. On the field, you never knew who he was rooting for as he called the games. He just was absolutely fantastic. And he passed away like maybe a year and a half ago. And I have a couple of his bobbleheads, and those are my favorites.
Oh
Believe
my
it or not. Yeah, not my favorite players would be the favorite bobblehead. It's Vin Scully.
Oh, that's very cool. So
Yeah.
I'm just going to ask our attendees today if any of them have bobbleheads too, because I think that's kind of interesting to see that. I mean, everybody collects something different, and I just love that.
I
So,
think I've got like 70 of them.
wow, that's
Yeah.
quite the collection.
Yeah.
Yesterday we were talking about pets, somebody having like more than 5 pets. I think you take the cake for bobbleheads. People are chiming in. Kevin says no, he has no bobbleheads. But if people chiming in, maybe they could tell me how many they have, because that's pretty fascinating. Okay, so today you have got an amazing topic you're going to be speaking on, and I'm first going to do some housekeeping. So
Sure.
I just want to remind everybody that today's event is worth 1 CEU. As long as you're logged in and we can see your name inside of the chat boxes and etc., you will be receiving that certificate. You can't just phone in. There's handouts for you, so if you need a handout, please let us know. They are not attached to this, so if you would like a handout, please put that in the question box so we can make sure that you have that. If you have any questions for James, you can ask those as well, and I will read them to him as we get the opportunity. And then, of course, because James is such a phenomenal speaker, you will want to see this again. The information is going to be great, so you can check us out on the Macro Pro YouTube channel, where we have lots and lots of different programs there for you to watch. Now, James, I believe you did this particular topic at the WCCI or something. Is that right?
The CCWC, yeah, we did this. Not this exact presentation, but it was based on this. The only difference is my co-stars, who are both amazing, Danny Thorne of Benchmark Administrators and Kathleen Wojcik of American Airlines. I don't have them with me today, and I can't make up for them because they were wonderful. But it is a very interesting topic. I think people will. It's a very important topic too. I think people are going to enjoy it, at least be interested by it.
It's really important to be able to identify, and handling these claims. The exposure is gigantic in some cases, or as you say here, mega claims. I think we want to be sure that we watch that and really take note of what you have. So again, if you would like to have a copy of the handout that James is doing today, put that in the question box and we'll make sure that we get that to you. And then Jeremy Bragg says hello, and someone else that they would love to have a copy of the presentation. I'm just looking to see if anybody has any bobbleheads for us to talk about here. So yeah, I don't see any bobbleheads, but you have a great presentation. I'll see you at the end of it.
All right, sounds good. All right, so basically what we're going to talk about today is high exposure claims, catastrophic injuries, and the main focus for today is going to be identifying those kinds of claims that don't look like they could be high exposure claims. They don't look super scary, but they have the potential once you get some more information. And there's a number of warning signs to look for. So we're going to go through that. We combed the internet, we combed all resources we could find so that we could try and figure out what the numbers were with respect to high exposure claims. And the reason for that is because they have such a big impact on a program in terms of the overall spend and costs. People don't realize that one case, I mean, it can equal 100 small cases And sometimes you don't even know that it's a high exposure case in the beginning until it's too late. And so if you look for these warning signs, then it's going to help you catch them earlier so that maybe you can put them away before, and we'll discuss it further, but put them away before they become what the potential that they have. So what we did is we got some numbers from the WCIRB. The WCIRB did a national analysis of mega claims, they called them. They defined them as claims that exceed $3 million, and which is obviously a very high exposure. I was actually more interested in $1 million because to me, 1 million is a very high exposure claim. But this WCIRB, they believe 3 million is that number. And so they did a very good national study. It's an impressive study, lots of data in it. And one of the things that they said was that a mega claim happens 0.04% of the time. So that little white sliver there that you see in the green pie, that's the number of mega claims out of the whole claims world. So 99.96% of claims do not fall into the mega claim category. So then they broke it down, they looked at the warning signs by industry and occupation, and they determined that 41% of mega claims fall in construction. And then you can see some of the others that are big contributors, such as office and clerical at 10, manufacturing, stores and dealers. The all other is just all outside of these industries, which are big industries. All other industries combined were 26%. So they did a study of construction because it was the biggest contributor. And what they learned was that 1 out of every 5 claims overall that involve construction, but 2 of every 5 mega claims involve construction, which means they're basically double the average. And so when you look at this pie here, you'll see from $3 to $5 million, construction's 37%. The 5 to 10 million, it goes up to 42%. And then you get 10 plus million and it's 46%. So construction's 46%. And there's a lot of, there's a lot of industries. So for it to be 46%, it's obviously a big contributor to mega claims. They evaluated mechanisms of trauma. What type of mechanisms of trauma are likely to cause mega claims? And what they found is that the biggest contributors were slip and falls. And that doesn't mean like that you slipped. It could be a trip, it could be a fall off a ladder, things like that. But basically falls, slip and falls, then motor vehicle accidents, then being struck by an object. The leading cause was slip and falls. They found that 35% of all mega claims are slip and falls. And that actually, it makes sense when you think about construction, because construction, they're working at heights very often. They're on ladders, they're on second floors, third floors, things of that nature. And when they have falls, it obviously can be a big injury. The next biggest was motor vehicle accidents. And crazy as it sounds, motor vehicle accidents only involve 5% of all claims, yet they're 20% of mega claims. And that's what makes motor vehicle accidents such a difficult animal to defend, is because so many things can happen from them. They're very high impact at times. A lot of them result in death. Most of the death cases that I've had over the years, which is unfortunately a lot, they've arisen from motor vehicle accidents. Head and brain injuries. This is they evaluated head and brain injuries, and I'm going to show you a stat. So 5% of all claims involve head and brain injuries. And I'm just going to ask you to think to yourself, what percentage of mega claims do you think involve head and brain injuries? And the answer is 74%. 74% of mega claims, 3+ million, are from head and brain injuries. And so what does that tell you? That tells you that when you see a head or brain injury in the application for adjudication, you need to take it very, very seriously. They're the hardest to defend of any type of claim there is, and the reason for that is many, but one is, for example, that when they have a brain injury and you impeach them, for example, they say, well, I have a brain injury and I didn't know. Or it's very subjective, and these doctors will rely on the subjectives, and then these claims, they just blossom and they turn into attendant care, home care, you name it. They just get real nasty. So when I see head and brain injuries, I get nervous. So as I mentioned earlier, I was very interested in knowing about the stats for 1 million plus. The National Council of Compensation Insurance, they did a study, and they, based on 1 million, and they indicated that 10% of losses, 10% of all losses come from these $1 million claims, but they're only 0.2% of claims. And so if you really think about that, that means there's almost no claims, yet they're 10% of the losses, these 1 million plus. They predominantly involve multiple body parts, which obviously makes sense, because if you've got just one body part, it's hard to get to a real high exposure. Even if it's something like, an amputation of a hand or something, it's still less likely to get to $1 million. But once you start adding up the body parts, the other systems, things of that nature, then that's how you get to that $1 million. And then they indicated that motor vehicle accidents and slip and falls cause about half of all claims above $1 million, which is consistent with what I said earlier, 35% slip and fall, 20% motor vehicle accidents when it comes to the mega claims. So it's pretty much in line. Their studies were, I think, pretty consistent with one another. So now what we're going to talk about is the warning signs. So what happens is you get a case, it comes in, and you got to start investigating it. And as you're investigating it, you start these warning signs start to pop up, and you got to keep your eyes open for it. And you should be looking for them in every case. I mean, in reality, some are obviously not going to have warning signs. They're not a big deal. The vast majority are not really a big deal. But mixed in there every now and then, you're going to see one that was unsuspecting, and it has a high potential for big exposure. And so you got to look for those signs so that you can catch them, because the key is to catch them before the other side does, because you get a good attorney, they're going to magnify it and try and blow up anything they can. So if you're on the outlook looking for warning signs, you're going to have a head start, and maybe you can do something to protect your client. So the first warning sign we're going to talk about is body parts and the number of specialties. The more body parts you see on that application, the more specialties at play, the more costly the defense, and the higher potential you're going to have for a very expensive claim. So when I see an application come in and I see neck, back, lower extremities, upper extremities, brain, I get nervous because I know that it could get expensive. So what I want to do is I want to knock that case out before it can become something. The next warning sign, and this is one that I gauge the most, is the applicant attorney. Who is your attorney? There are some. The way I look at attorneys is you've got a spectrum. They all fall somewhere along the line. On this side, you got these mills that are just take any case, it doesn't matter. They just want to close it as quick as possible, move on to the next. Then you've got a large chunk of attorneys that are just working up the cases, do a good job, good attorneys. And then you got the sharks, the ones that are super difficult. Getting anything done is it takes a lot of time. They try and build up every specialty there is, and they're just very difficult. So when I see the applicant attorney, I think, is this one who is going to settle the case with me, or is this one who I know is going to put me through all the hoops? And that's a big deal. So applicant attorney, if I see one that I know typically likes to settle and I see a bunch of warning signs, I'm jumping on it, trying to get rid of it ASAP. The next warning sign is age. Age, you get an older person and they come and they allege a CT claim, and it's got all kinds of body parts and systems, and there's no medical evidence yet. You can almost be certain there's going to be some findings. And so older applicants are going to likely have more findings that are already existing that get worse because of an injury. they're going to have pre-existing conditions such as diabetes, things of that nature, because especially once someone hits 65 years old, it's a major risk factor for a lot of different chronic diseases. And you can have, knee issues, knee replacements, and it could be completely unrelated to the work, but once they have some sort of an injury, all of a sudden that small percentage of causation becomes, big exposure for your client, for your carrier. The next one is medications. If you see somebody who's already on medications, then when I say medications, I mean like painkillers and Xanax and opioids and all those types of things, Vicodins. They're taking that stuff already. That can become a problem because it can show, first of all, it impacts their recovery, obviously, but then it can also result in addiction, in that they can get addicted in your case as well. And then I've had cases where I can't settle it because the person's so addicted to the drugs, they're fine. They can go back to work, but they don't want to give up those drugs. So prescriptions are a definite warning sign. In and of itself, any of these of themselves, they aren't necessarily going to mean that there's a big exposure, but the more of these warning signs that you have, the more concern you should have. Drugs, smoking, and alcohol. If you've got someone who is already addicted to drugs and they smoke and they have alcohol, they're likely to have some health issues already. And so that can be brought into your claim, whether it be blood pressure, cardio issues, whatever it is. Alcohol eats up the kidneys. It can definitely bring problems to you. So that's another warning sign. Psychological issues. If you have someone who already has some psych issues, they tend to think more catastrophically. They tend to think, woe is me, I can't beat this. And so what you're going to have to deal with is how you're going to get rid of a case where someone just doesn't feel like they can recover. And they say that there's a 38% of the variance for people who can or will not recover from a physical injury. The 38% variance is caused by psychological issues, and that's a pretty big number. So that's definitely a significant warning sign. Mechanism of trauma is a big warning sign as well. I touched on it earlier with the WCIRB numbers. Certain mechanisms, they're more likely to blossom into big cases. So you've got a mechanism of trauma where someone falls from a second floor or a motor vehicle accident. It's really important versus someone who's just bending over. Maybe they're picking in the fields and they bend over and they hurt their back or whatever. Those types of mechanisms of trauma are not going to be nearly as concerning as something like getting hit on the head by an item or falling or a motor vehicle accident. So mechanism of trauma is very important to look at. When I have a car accident case, even if it looks like it could be benign, car accidents, they turn into a lot more oftentimes because they involve body parts that are hard to pinpoint if there's injury and findings, to pinpoint the cause. And it's easy to say, well, it was the car accident. He was at 40 miles an hour, and then there was the impact, and it jostled the body all over, and we all know how they are. And so they'll look at things like how much damage was there to the car. If there was a lot of damage to the car, then you're going to have a lot harder time defeating injuries, even though it doesn't seem like the accident was even the cause necessarily. But because the impact is so big and the damage to the vehicle is so much, then doctors are just persuaded heavily by the mechanism of trauma. So mechanism trauma is a big deal and definitely one of the warning signs. Next is prior injuries and surgeries. And we're always looking for that apportionment. We're always looking for prior injuries. I usually get excited for them. I mean, in reality, because it gives me arguments. I can take a deposition, see if they're honest. Do they tell the truth about their prior injury? And if they don't, it impacts their credibility, and it can even defeat an admitted claim, which I've actually had happen, because they lie about it, and then you go, okay, well, since they lied about that prior injury, we don't know whether this injury was real or not, and then all of a sudden you've got a potential defense, even 2 years later or a year later or whatever it is. But prior injuries also have a negative, and that is if someone had a significant injury in the past to the same body part, and they're honest and all that, then we could adopt whatever that future medical is. We could be liable for that future medical, et cetera, as a result. And so if, for example, somebody had a prior back surgery and the metal was still in them and they never had it removed, and then they have some sort of an injury, well, that could end up becoming another surgery on us, even though it was a small injury, but it aggravated or it worsened the prior injury, and now they're worse than they were because of the new injury, and we get all of the medical. So prior injuries and surgeries are good, but they're not bad. And I'll give you an example. I had this case some years ago where this guy ended up having his leg amputated, and he had a settlement prior to our injury, where he settled for like $425,000, and he had osteomyelitis, lots of infection going on in the leg. And after it settled, he had an incident at work, and he had some injury to the leg, the same leg, and so it ended up resulting in a complete amputation. And even though this was an extremely minor injury, it was the straw that broke the camel's back that resulted in him losing the leg. And so it became obviously a high exposure big case, and it was something that really shouldn't have even been ours. He had the major issue already. He already had osteomyelitis in the prior case. And so it was clearly pre-existing in very large part, yet it falls on us. Now you get apportionment, obviously, but the medical care is and the assisted living and all of those types of things, and then it impacts the internal system. The high blood pressure and diabetes can be impacted, all those types of things, and so all of a sudden we got this nightmare on our hands. So that's prior injuries and surgeries are definitely something to look for, both ways. It could be good, it could be bad. Obesity is another one that we have to look at, because weight causes a lot of harm to our bodies. On the joints, it causes significant degeneration. It causes many problems, and diabetes and kidney disease and the various things that can result from it. And so it's a major risk factor. And so when I had a case where this woman was 400 pounds, 5'2" I want to say, and she banged her knee on a desk, and it was a nothing. It was an absolute nothing. And she had 2 prior claims as well, super messy. And so they said that she needed a meniscus repair from banging the desk. But in order to get the meniscus tear, she needed a weight loss program, and she needed to lose something like 200 pounds or something along those lines. Gastric bypass, they said. And so it turned into this big claim. She had a lot of other medical conditions that were being brought into the case. And so here we are with this minor banging of the knee on a desk, and we're facing this gigantic exposure. And it was because of the obesity. And so that's a significant warning sign. Pre-existing medical conditions. I've kind of been touching on it all along. This is one of the ones I look for the most, and I want to know things like if this person, I've had cases where they have stage 4 kidney disease, chronic kidney disease, or they've got type 1 diabetes or type 2 diabetes, even type 1 is worse than type 2. Um, these types of pre-existing conditions can be brought into certain cases. And if you got this minor knee injury and they just get a little bit of physical therapy, things like that, I'm not too worried about it. I still want to get rid of it, but it doesn't necessarily mean that you're going to have this huge exposure. But if you have a significant mechanism, or maybe their surgeries, things like that, and they've got these pre-existing conditions, and they can show that the numbers are higher, than they were before the injury based on the prior records, then they can say that the injury worsened those conditions, and then the future medical could be huge and put the big liability into the case. So for me, I look at pre-existing medical conditions. It's one of the top things that I'm looking for. It may not be alleged in a case, but if it exists, we need to deal with it, because we know workers' comp. We know how these things can get into cases, even when it seems like they shouldn't be in the cases. Next is prior litigation history. Now, this is really more, I like to know prior litigation history so that I can understand the psychology of this applicant. And you may have someone who you look in their prior litigation history and they've got 4 claims and they all settle quick. So you know that this is an applicant that you can typically settle with. Or maybe they got 1 claim and it settled quick. Or you could have an applicant who has had a couple claims and they didn't settle quick and they lasted forever and they went to trial in their F&As, and then you go, uh-oh, this is one of those types of applicants that wants his day in court, and they exist. I had a case where I couldn't understand why the guy wouldn't settle, absolutely wouldn't settle. Everything was there, it was ready, and it turns out he wanted his day in court. I mean, it was fraud. I mean, this case, he was nailed. And it weren't often very much money, in reality, but it didn't matter. This guy wanted his day in court. And so I find out in his prior litigation history that he had had 2 prior claims in the past, and in both of those claims, they went to trial. He was not one that wanted to settle. And so I know that, and that tells me, okay, we got to be super aggressive with our defense, line everything up, because this is someone who, and it's probably a psychological issue, as I was mentioning earlier, that resulted in this thinking. But if they're gonna fight to the end, then you need to be ready to do what you have to do to mitigate your losses. Another red flag is anytime you see a case where home care in assisted living, things of that nature could become part of the case, you got to pay attention to it, because those are one of the biggest drivers there are in catastrophic and high exposure claims. The applicant attorneys use it against us left and right, and they come up with these ridiculous valuations of lifetime care. They're going to need 8 hours a day by a nurse, or they're going to need to be in a facility 24 hours for 17 years or 28 years, whatever it is, and they give you these calculations, and all of a sudden the home care is twice as much as the rest of the case. And so it's if you see a case that could be this way, then you're going to want to, it's a warning sign. I had a case, for example, where the woman was alleging diabetes, and that her diabetes was exacerbated, and it caused it caused blindness. And it was a field worker claimed chemicals. That's what it was. Chemical exposure in the fields worsened it. And so we're like, this is ridiculous. This woman was already having all these problems. There's no connection. And so the doctor ends up giving his opinion, and he says, I attribute 5% of it to the job, 95% of it pre-existing. Well, she's now blind. And what does that mean? That means you've got to go in there and you've got to modify the home, if it can even be modified. You're going to have all kinds of home care and assisted living, driving, you name it. They can't do much of it, especially someone who has never been blind. And so it's going to be an extremely costly case. And in this particular case, it was strange enough. I mean, I didn't believe it was work related at all, and I was going to challenge it entirely. And then the AA made a settlement offer saying, well, obviously the PD is not the exposure, it's all of the home modifications and care that are going to be needed to take care of a blind person, and made a settlement demand, and we ended up taking it because it was a very good settlement demand. But the funny thing is I didn't agree with them at all. And the reason why is because Labor Code 4662 has a presumption of 100% PTD if there's blindness. So he had the blindness. So really he could have been going for 100%, and he didn't. And because of it, we were able to settle. But I can tell you there's many applicant attorneys that there's no way they would have been willing to do that. Even with what I thought we had were good arguments, they would not have settled for anywhere near this amount. And they certainly, the good attorneys certainly are not going to, they're going to know about Labor Code 4662, put it that way. All right, next one, job duties and years worked. This is a big one. You see a 20-year CT from a construction worker or someone working in the fields, bent over, picking, carrying big sacks, for 20 years, things of that nature. You're going to go, this has got potential, especially if they list a bunch of body parts and you got to deal with all of that, and they're older and you get all these warning signs. But job duties and years worked are very important because we break down. Our bodies break down, and that's cumulative traumas are real. They're most certainly real, and so you could have someone who alleges a specific, but they've been doing it for a long time. They're going to probably have some pre-existing findings in there, but both from life and from their job, and that's going to impact the exposure of the case. So you definitely look at that. And you also look at the activities throughout the applicant's life. If they have a history of sports and things of that nature, that is going to have, it puts wear on the body. And so, people say running is so healthy for you, and of course it is, but it also breaks down your knees. So I had a case, for example, where this woman was a marathon runner, actually a professional runner at one point, had a slip and fall, and alleged that her legs, both of them, and particularly her knees, were injured in the accident. Well, they were an absolute mess because of all the wear and tear they had had throughout her life in terms of largely from running. I mean, you run on cement over and over and over. That's really important. So you want to find out, what are the hobbies of this person? What are they all about? What have they done? And because those types of things will result in abnormal findings that can become part of the claim. Another one that we all hate is potential Medicare involvement. If the person's 65 years old on Medicare, that's, you're going to have a tough time. If they're 62 years old, they're not eligible for Medicare, and at this point in maybe they're on Social Security, and you can get to the $250,000 guideline for CMS, then you're going to have a little bit easier time because you got more to work with. But potential Medicare involvement is one of the biggest. And I had a case where a guy was hit in the head, and he went blind. He lost his vision in both of his eyes. 100% case, obviously. Presumptive, no apportionment allowed per LC 4662. And he was also a longtime alcoholic. He had a number of health issues already before the injury. I think I don't remember how old he was. He wasn't real old, but it wasn't like 65 or anything like that. But he was probably in his 50s, if I remember correctly, early 50s. And so he had a life expectancy. And it turns out we see the records, he had chronic kidney disease stage 4, which what that means is you're on dialysis, you're probably a candidate for a kidney transplant, which is very expensive. Not to mention kidney transplants only last, I think, 10 years. So you could have 2 kidney transplants. And so essentially we had to deal with that. We had to deal with hypertension. He had hypertension and he had diabetes. And so we got the MSA. We were going to try and settle with a shark, really, really good AA, one of the top AAs there is. And we were just so far apart, like 10 million apart on the case, and we just weren't getting it anywhere in terms of settlement. CMS was causing us problems because the MSA was so high. And part of the reason the MSA was so high was because there was $1.4 million just for the kidneys. The kidneys had to be, it's indicated that his kidneys needed to be replaced. And so there was a dispute whether the kidney disease was caused by the accident or whether it was entirely pre-existing. And so what I had evidence of was that he had it beforehand, and it did go up a little bit as a result of the injury, understandably, but then it went back to the level it was at before. And so we ended up having to go to trial on that, as well as the same issues with the hypertension and the diabetes. And so the MSA for the hypertension was it was under 300, and the same with the diabetes. They were like 250 and 280, I think. And so we went to trial just on those 3 issues, and the goal was to show they were not work related so that we could get them removed from the MSA. We went forward, and I had to ask a lot of tough questions from a guy who's sitting in his wheelchair, blind, and I'm having to ask him all about his alcohol use and things, very, very tough things to ask when you're dealing with someone so horribly injured. But it's part of the job, and you got to do it. So I did it, and we ended up getting an F&A, and the F&A had the judge found the hypertension work-related, the diabetes work-related, and the kidney disease not work-related. So we won on the 1.4 million, and we lost on the other 2 that were just a little over 500. So now we have a dilemma. Do we appeal? Do we recon? Or do we hope that the AA doesn't recon, because we considered it a win? Obviously, we were so worried about that kidney disease. And ultimately, we decided that we needed to recon it, because I knew this attorney. I knew there's no way he wasn't going to recon the kidney disease. It just was too big. And so we ended up working, doing an amazing petition, put a lot of time into it. And sure enough, 2 days or 3 days maybe before the due date, we get the applicant attorney's petition. So we filed ours, and then thankfully, and otherwise what we'd have been doing is we would have been just defending our win instead of having a chance to overturn the losses. And so because we had that F&A, we ended up coming to a settlement. That is part of the reason. It was other reasons as well, but we ended up getting a settlement that was very, very fair for everybody. And this applicant attorney, I know he didn't feel like he did. I know he feels like he lost, but he didn't. It was fair for everybody. So Medicare involvement can be a nightmare, and we've all dealt with it. And anytime you can avoid it, by getting rid of a case early before it's even an issue, do it. All right, so now we're going to do a few case examples. These are based on some cases that I've had over the years. This first one, he's a 55-year-old male construction worker, 30-year CT in construction, doing a bunch of heavy work. application comes in, it alleges all 3 levels of the spine, upper extremities, and then both lower extremities, nothing else. So we look at the AA. Who's the AA? It's an AA who is notorious for building up body parts and systems over time, but we've had a lot of success settling early. So I look at it and I go, okay, we've got a chance here at settlement. We'll see what it's all about. We had coverage for the last 3 years of the CT, so it was entirely ours. And so we see a lot of cases with facts like this. We handle them quite often. But what we don't see often is when we get early on in the case, personal medical records, and they include things like, in this particular case, stage 4 chronic kidney disease, diabetes type 2 for 10 years, hypertension for 10 years. Those, I see that and all of a sudden I start going, uh-oh, this is a scary, scary case, because it is not hard to tie these systems into a 30-year CT for a construction worker who's likely going to have 55-year-old man who's likely going to have significant findings. Who knows if there's a surgery that's needed, and surgeries are big causes in terms of increasing kidney disease, diabetes, hypertension, those types of things. And so they can, once there's that surgery, if they can show that the numbers increased, they're going to have a pretty good argument. So I saw this and I immediately tell the client, hey, there's a number of cases that are like this that over the years, but so I immediately tell the client, we've got a big issue. We need to work on settling this. Fortunately, this person was not Medicare eligible, so we didn't have to deal with that. But let's say they were Medicare eligible, and they're not on Medicare, and you want to settle this case. You want to get it for under 250, and you can settle it for, say, 200, which in this particular case we did settle it for 200. Didn't need all the med legals. We didn't need all that other stuff. We had an attorney willing to settle. We knew the history, and I don't know that the other side knew about it because they didn't allege it, but when I saw those medical conditions in there, I know what this thing it could turn into an absolute nightmare. It could be $1 million, it could be a mega claim, these types of cases. So don't mess with it. And so we didn't mess with it. We got rid of it, and anytime we see this type of a fact pattern, we get rid of it. At least I recommend it. Not every client would agree to do it. Here's another case example. This is how we doing on time. We're good. 38-year-old male has a specific trauma where he fell from a ladder onto a cement floor. He was hospitalized for a few weeks. He had very serious injuries, had a couple fractures, but he had an aortic disruption, I think it was, and it was very serious. And so he was hospitalized. He was also unconscious. And he woke up in the hospital and didn't know where he was. And so after 2 weeks, he was released, and he had an amazing recovery in terms of like the aorta healed up beautifully. I thought he had an amazing recovery. The AA was one that was usually open to early settlement and not a brain injury specialist. I'm always looking, when I see head and brain, who is that attorney? It's the most important fact I'm going to know, because there's attorneys out there that can take a case that has no evidence of a brain injury really, other than maybe they hit their head or whatever, but MRIs are normal, diagnostics are normal. They get them into a long-term care facility or a doctor at one of those neuro centers that know how to build up claims. They rely on all these subjective findings, say, well, he can't remember this, and he has memory problems and headaches, and even though it's not verifiable, they still put it in there, and they're the most difficult claims to defend. So here we had someone who's not a brain injury specialist, so doesn't know that routine that they like to go through. and usually open to early settlement. The records did show the serious injuries, as I mentioned, and there was an indication of post-concussive syndrome. But there was no brain injury found by the diagnostics. In this one, he did have some cuts on the scalp and face, and he complained of headaches, memory problems, and double vision. In his deposition, he said he admitted to a prior claim, but he said it didn't involve the head. And the records showed, in fact, he said that our injury was to the left side of the body, the prior injury was to the right. That's what he said in the deposition. And so we had the records, and the records were to the same body parts. And there was even mention that he was having memory problems and headaches in it, but it was just the doctor's discussion of it. It wasn't like it was this main complaint of the case. So we really didn't know the extent of those injuries. We also did know that the applicant was on psych meds prior to the injury. We had very favorable med legal reporting. In fact, when we went to a neuro, because the AAs just wouldn't settle without the neuro because she was very afraid of the head injury. The neuro said that he didn't believe there was any permanent disability from the head injury. So it was very favorable. We went to MSC, and we had great reporting. The AA was willing to settle, and we had an opportunity to settle it for $85,000. And to me, it seemed like a no-brainer because of the fact that I just thought the injury was so serious that if a judge sees all the facts, the judge may just look at how the injury happened and the treatment in the first 2 weeks and things of that nature and blow it up. But we didn't settle it. Instead, we went to trial, and the judge said, well, I want to develop the record because this injury is just so serious. I just don't, I can't imagine there's nothing there. And I should point this out first. So we set it for trial, and in the time between the MSC and the trial, applicant subbed out the attorney and got a brain specialist. So now all of a sudden, I got to deal with a brain injury specialist who's doing all those things that I said. All he wanted to do was get the trial taken off, to develop it, claiming all these inadequacies, and it turned it into a big nightmare. And then suddenly the demand was $1 million when we had it done for 85. So in looking at it, I knew what this could potentially turn into, because anytime the brain is involved, and it was a serious injury, I think he fell he fell at least 8 feet onto cement and had serious injuries. 85 grand, it was a steal. Well, not a steal anymore. So the new attorney just completely changed the whole course of the case. And if we had adhered to the warning signs, we could have gotten rid of it. Instead, we didn't. So those are the warning signs. It's all very important. When you're looking at these claims, pay attention to them, because that small percentage of the claims is so much of the exposure in the big picture to the company and to the survival of the company. And if you can spot one of those or two of those a year, and most of you, when I say you, I don't mean each individual person, but your program, because a lot of you probably have never even seen a catastrophic claim. And so it's not something that's common, because as I said before, 0.04% are mega claims, 0.2% are 1 million plus. So you're not going to see them often at all, but you gotta spot those ones where you can have an opportunity to settle them early. Got to spot them right away before the applicant attorney does, and it brings issues in that really shouldn't even have been in the case, but that's what they do. You got an applicant who has a specific trauma, treating it, doesn't like something, goes to an attorney, and this happens all the time. Suddenly now I've got an application for the specific trauma as well as a new CT that alleges all kinds of body parts, and now you got to deal with it. A lot of them are are bogus claims, a lot of them. And the applicant certainly didn't come up with the idea of filing the CT. They went there because they had a specific trauma, and then the attorney said, "Oh, well, what about this?" and turned it into this CT, and the CT is actually the case you got to be more afraid of. But you got to look at the warning signs. So this is just a general list of CAT claims, some of the types. Death, I've handled a lot of death cases over the years, more than my fair share. And, it's catastrophic, but it's actually, believe it or not, for those of you who haven't had a death case, they're actually not the most expensive cases. We've got statutory caps that apply for most of them. You can get around these statutory caps if there's a minor child. I've seen the statutory cap for 3 total dependents is 330. I've seen it get into the million plus because I had one where there was a posthumous baby, meaning the applicant died at work and his wife was pregnant, and then the baby was born, and now you got 18 years of TTD, and the guy was a high wager. So that can happen, but the majority of the time, the statutory caps come into play. And so they're not big exposures. It's the ones where they don't pass away and they have, serious injuries and need lifetime care. Those are the ones that turn into the big exposures. So paraplegia and quadriplegia, those are obvious ones. And those are the kinds of cases where you don't need warning signs. You already know it. This was a big accident. It turned into the guy can't walk. He's got a brain injury and he's a vegetable, or he's in a coma, things like, there's certain, a lot of these CAT claims, as soon as you see them, we're going to have a tough time here. This is a major exposure. We got to get the reserves up heavily. And so this is a list of some of those that are indicative of CAT claims. Loss of consciousness is more, it's not just they lost consciousness for a minute. Loss of consciousness is, there's a significant brain injury. Amputations of major limbs, arms, legs, multiple fractures, break your back, your neck, your shoulder, whatever, major burns, and then severe internal bleeding. These are just examples. There's obviously more. So now I just want to talk about a few claims handling tips. Obviously, you want to do the right thing. You want to communicate as quickly with the employee and the family, let them know you're on top of things, you care, because this is going to be one of the worst, if not the worst times of their lives. And it's not just the applicant, it's the family of the applicant, it's everybody. And so you want to help them out as much as possible, know you're there, get whatever treatment you can to them so that they're taken care of, and at least they don't have the stress of worrying about whether the big bad insurance company is going to take care of them. The other, and this is a super important one, is collaborate with your management and your defense attorney partners so that you can work on a best fair outcome. You'll want to assign your high exposure claims to your more experienced adjusters and your best attorneys, and that's obvious as to why. But even if you're not an experienced adjuster, if you can spot the issues, that goes a long way, because then you can go to your supervisor and say, hey, I don't really know how to handle this kind of a case. It seemed like it was a smaller case, but there's these issues, and based on these warning signs, I just wanted to bring it to your attention so that you're aware. And I want all my attorneys to do this for me, because if I see these CAT claims, I want to have my finger on them. And so it's very important that they get it identified so they can be dealt with as early as possible. When I have a high exposure claim or one that I believe could be, it's important to increase the level of managerial review, and that's not just at the TPA and adjusting level, it's also at the attorney level in my office. It's very important that we work together and meet regularly. Like we have a lot of our clients will have regular reviews on certain files because they're monsters, and so maybe we meet on a Zoom once a month, sometimes more often, sometimes less, depending on the case, but we're talking about them. We're making sure that we don't have a stale litigation plan, that we don't have stale treatment plan, and that there's not a lack of effort to have a closure. It keeps everybody on their toes, and it gets us talking, and we come up with good ideas as a team. Everyone contributes. So that collaboration is really critical to handle these types of cases. So when you see a claim with warning signs, look for the warning signs. Once they're identified, try and settle it, because closing those early can save big bucks. And I can tell you, spotting those issues over the years, there's a number of cases that we've gotten information early on that we were able to settle and close, that based on my experience, we're going to turn into something big. So spot it and deal with it right away. And then lastly, this is just a checklist for you. It talks about all the things that we discussed today, of the warning signs, and so it's just there for your convenience. But that actually concludes it. You there, Diane?
I am. That was really fascinating. There was a lot of great information in that.
Yeah, it
You know,
really, it's important stuff. It may be, this kind of stuff can be a little bit dry, but at the same time, it is interesting, and it's critical.
Yeah, I think I have a couple questions here. Hold on, let me look
Sure.
at that real quick. How long does someone have loss of consciousness to be a CAT claim? Does 30 seconds count?
No, I mean, not to me, no. It's just a factor. If someone loses consciousness for 30 seconds, they could be completely normal and have, no permanent disability. But, when you take it in the totality of the circumstances of the injury, then that's a concern.
Yeah, absolutely. Well, it's very fascinating to hear about this, and it's wonderful to get guidelines for people to utilize to help identify what is going to be a catastrophic claim, or a mega claim, as you call it.
Well, I don't call it that. That's the WCARB.
Is that right? Is their
Yeah,
terminology?
that's
That's a
theirs.
little hip for them. I like it.
Yeah, I like it too. I just wish they would have done 1 million, because to me that's the number. But 3 million, I get it. It's fair. And they did a great study. It's available too. If anyone wants that study, that I'd be more than happy to show you how to get it.
Why don't you give your email, James, so that they can email you if they'd like that?
Sure. It's you can go at jr@ca-sil.com.
Excellent, thank you. So speaking of great presentations, we have more presentations coming up, so always make sure that you look at the MacroPro website for those. We have an exciting one coming up. It is, you get to ask the applicant copy service any question you want webinar. So if you have questions, you always wonder why they do something, or if you have a question on the fee schedule and why they do things, bill accordingly, this is your chance. You need to email me your questions at Diane, DIANN, at macropro.com, and we will ask those questions and build them into the presentation. We'll also have defense copy services there, but I think most of you would really like to ask questions of our applicant copy services. All right, well, James, thank you again for a wonderful event and webinar. For the rest of you, those of you who have asked for a PDF of this program, we will make sure that you do get a copy. I'll leave that open for just a few more seconds, so if you want one, type your information in. Otherwise, James, thanks so much, and we will see you later. Bye-bye, everyone.
My pleasure. Bye, everyone.